All right, well, we unmuted. Okay, yep, sorry. Welcome everyone. We are now unmuted and we will begin today our council extraordinary meeting, and I'll just begin with karakia. Tue ki runga, tue ki raro, tue ki waho, tue ki roto, tue ki te here tangara, ka ronga te pō, ka ronga te ao, haumie, huie, hai. Today as well is appropriate. Oh, sorry, thank you, Councillor Wilson. It is appropriate today as well that we have a moment's silence in a moment. It is with great sadness that we acknowledge the passing of Kingi Tuhei Tua Otago Te Whero the Seventh. On behalf of the Otago Regional Council, we extend our condolences to the whānau of the Kingitanga and to all who mourn the loss of this esteemed leader. Kingi Tuhei Tia, his dedication and contribution to his people and the broader community will be remembered with great respect and admiration. To mark the burial of Kingi Tuhei Tia, the Otago Regional Council will be flying the flag at half-mast today. Our thoughts are with all who are affected by this loss during this time of mourning. Please join me in a moment's silence. Thank you, everybody. Moving into the agenda, are there any apologies? It looks like we may have an apology potentially for lateness from Councillor Tim Metham. So I am happy to move that. Does somebody want to second that? Yeah, Councillor Noon, all in favour? Aye. Against, carried. Yeah, we have Councillor Alexa Forbes joined us online. Welcome, Alexa, as well. Sorry, Councillor Kelleher as well, of course. Thank you, and welcome to Councillor Kelleher. There's Tim now. Yeah, and there is Tim too. So great. We have a full muster of councillors today. No apologies, but we have just passed one for lateness anyway. Brilliant. Okay, so confirmation of the agenda. We can confirm that it is as advertised. Any declarations of interest, there is a reminder there as per normal to manage those should they arise. Now on to resolution to exclude the public, and I'll just note that at this point we do have Michelle Malhoft with us as well from Wynne Williams as a legal expert. But yeah, just I would like to move that we go into public excluded from the following parts of the meeting, namely the draft response to the Minister for the Environment regarding the proposed land and water regional plan, and as part of that I further move that Christina Robb, consultant, be permitted to remain in the room. She wrote some of the report and her, due to her skills and knowledge of the item. Somebody care to move, second that, sorry. Yeah. Councillor Weir seconding. Now, are there any questions or debate? Councillor Laws.
Yes, I'd like to object to this and very strongly that this meeting is to go into confidence or into secret to discuss something that is clearly of considerable public interest. And I want to say how disappointed I am with the legal opinion that's been provided to you. because it does not seem to recognise the overwhelming principle of availability under Section 5 of the Local Government Official Information Act of 1987. The default position when it comes to council business is openness, transparency, and public communication. And this motion runs entirely contrary to that overwhelming principle of the Act. But I find particularly specious, I have to say, the two rationales that have been used. The first is something that is just nonsense. The suggestion is that there's some form of legal privilege here under Section 7. I don't know where the legal opinion came from, but I tell you what, it wasn't looking at the Ombudsman's case note reports on this particular issue, because the Ombudsman's case note reports have made clear ever since, in actual fact, Lagoima was in place, the most recent one from Peter Boshier in September 2021, that legal privilege can only be used as an excuse if it is to maintain legal professional privilege, solicitor-client privilege, and litigation privilege. Those are the only two legal reasons to do so. There is no solicitor-client privilege in terms of the issue that we're about to discuss, which is the letter from the Otago Regional Council to the Minister Penny Simmons in response to her communication of the 8th of August, asking some specific questions. Where's the legal privilege? Where's the solicitor-client privilege in that? There's no legal opinion attached at all, and I want to say this publicly. There is no legal opinion attached at all to this paper. Nor is there any litigation privilege here. We're not involved in any litigation with anybody. We're taking part in litigation against anybody else. The other reason for withholding official information is to protect information, apparently according to the motion, under Section C1, to protect information which is subject to an obligation of confidence and likely supply the confidence to similar information. The information that we've been provided is all public. Every piece of information that's provided in the Section 32 report is easily procurable through public means. There is nothing private nor confidential that's being shared with us. And those are the only two reasons that have been provided as to why we will exclude. The purpose of the Local Government Official Information Act, I can't tell you how annoyed I am because I've given this speech for 7 years, is number one, the purpose of the Act under which we are seeking to exclude the public and the media and everybody else who might have an interest in this particular issue, is as outlined to enable more effective participation by the public in the actions and decisions of local authority and to promote the accountability of local authority members and officials. I use that last word advisedly, and officials. The principle of availability is Section 5, the purpose of the Act, Section 4. The specificity of Section 7, under which we are excluding or seeking to exclude public gaze, is specious to me. And just before you say, oh, I've got a legal opinion, can I say, and I don't mean this to be offensive, but I'm going to say it, I can get a legal opinion on anything. Lawyers at the end of the day are hired guns, not hired guns. They are responsible for providing legal opinions. And the reason that we have a legal system is because there are so many conflicts of legal opinions arising in our court systems, whether they're the Environment Court, the High Court, the District Court, or the Court of Appeal. There is no one truth that comes out of a legal opinion. They are simply that, an opinion. And my argument is this particular opinion is in breach or does not satisfy the particular or provide sufficient evidence. And that's the next point I want to say. The Chief Ombudsman has been saying repeatedly to councils, you can't just use a section of the Act and say, this is how we're going into, this is why we're going into confidence on this particular matter, whatever it might be. You've got to provide reasons for the withholding. In other words, there has to be evidence that satisfy that. Where's the evidence in this? Where's the evidence in the opinions? I'll say this once and for all. This is an extraordinarily important public issue. It is an issue on which literally thousands of lives will depend and be governed by, to do with the ORC's draft and land and water reservoir plan. Everything that we've done has been pretty much in the open on how we've approached this. We've had workshops, for God's sake, which have been available to everybody, and I welcome that openness and transparency. But just when we're answering a question, which we've been publicly asked by Penny Simmons, the Minister of Environment, nope, we want to go into confidence to discuss it. Why? What's the matter with the truth, with openness, with honesty? And oddly enough, these are the overriding values of the Otago Regional Council. When you all signed up for them, there they are on the front page of the ORC. What are we all about? Openness, transparency, honesty. This is the exact opposite of that. I say to members who I will differ on perhaps the value of the draft and land and water plan, for God's sake, don't get yourself sucked into doing dirty deeds in public. If you are going to make a decision, for God's sake, justify it in public, sorry, dirty deeds in private. If you are going to do it in public with rational evidence. You believe that you have a good argument, then utilise that information so that we can all see and so that all of Otago is aware. Madam Chair, I have railed against the instinctive tendency of the ORC to try and conduct its private business or anything that seems slightly controversial in private over the years. It's done us no good. We've recognised that as a council. There is a realm of case law from the Ombudsman on this matter that supports this point of view. I think that we should hold it in public and do everything so that everybody in Otago is aware of our actions and the reasons why.
Thank you. There are a number of matters raised there, and we didn't have time for questions, but we have got a legal expert with us from Wynne Williams, Michelle Malhoff. There are a couple of things there. One question that was repeated a few times there, which was where is the legal privilege? And the other one was around the section 32 being all in the public arena at the moment. So I'm wondering whether or not we could answer those two, and there may be others that were raised as well.
Question when you're not there.
Michelle, are you able to?
Yes, kia ora koutou. I'm happy to address those matters and give you some further legal advice on that. I just confirm with you whether you wish to take that advice in public or move into public excluded to take that advice. And I just ask that question as a matter of course for you to consider before receiving legal advice.
Yeah, we'd like to have it in public, thank you.
So in terms of the advice that I've provided in relation to this meeting being whether it is public or public excluded, I have considered the grounds under section 48 of the Goima and in particular section 7. The two grounds that I have referred to, and I will address both of them if I may. The first is in relation to an obligation of confidence, and the second relates to legal professional privilege. Now, the reasons that I have considered these grounds in relation to this meeting is that the purpose of the meeting is to consider the response to the minister. That's my understanding. And my understanding is the draft response to the minister contains draft extracts from the draft section 32 evaluation report for the proposed land and water regional plan, and it also includes references to the draft land and water plan and changes to the draft plan since engagement and consultation has been undertaken. So it's within that context that I have considered the grounds under Lagoima, and I have been very cognizant of the purpose of Lagoima and the principle of availability and having these meetings in public. The first ground that I have referred to is under section 7 2C, and that is in relation to the obligation of confidence, and that this meeting would disclose information that is subject to an obligation of confidence. And that is, on my understanding, that the response to the minister at this stage would be a response that is made in confidence to the minister, given that the material attached to the response is still in draft, being the draft extracts of the section 32 report. So, and I appreciate the comment around the section 32 report being public material, and yes, it will be when it is finalised and it is provided to the council to have particular regard to before it makes its decision whether to notify the plan or not. But at this point in time, it is draft. It does discuss options that are being considered that have not, in terms of my understanding, been subject to a council decision yet. So at the moment, it is still draft material. And that there would be a damage to the public interest or prejudice in making draft information available that parties may rely on to their detriment, or parties may have advance access to that material ahead of others. So you end up with a risk of procedural unfairness of having draft material in the public arena that some may be privy to and see, and others may not, rather than working through the public participation process that is provided through the Resource Management Act in terms of the steps for preparing a regional plan. So that is the context within which I considered that ground in terms of the obligation of confidence. If the response is being made to the minister in confidence at this point in time, then disclosure of that material now as a result of this meeting would prejudice that obligation of confidence. The second ground relating to legal professional privilege, I considered that ground, I would say, as a supporting ground on the basis that the Section 32 report is still subject to legal advice. If the Section 32 report was to be discussed today, matters that were subject to legal advice and legal advice that had been provided may be discussed. So that was included as a supporting ground to the Section 7 obligation of confidence ground. And I would say that there are decisions of the Ombudsman where a draft material has been requested and the obligation of confidence ground has been upheld on the basis that of the risks of premature disclosure of draft material that will be subject to council deliberation and that is still under active consideration by the council. So those were the matters considered.
Thank you, Michelle. Right, so I think you were first, Kate.
Thank you. Look, Want to just check my understanding of the legislation and recovering lawyer as I am, that I've probably lost the completely, but section 48, sorry, the Act generally is, the presumption is that things are open. I'm correct on that? And section 48 is very clearly headed up with the word may, not shall, but may. Is that correct?
Section 48, that the council may by resolution exclude the public.
Yeah.
Yes, it's may.
If it's got the grounds, it doesn't need to necessarily. It has the grounds to do it, but it's not a shall do it.
Yes, so I've provided legal advice on the grounds that the council may exclude the public, and it will be for the council to make that decision whether to exclude.
Thank you. Now, and just taking Councillor Law's points a bit further, while we have that ability to choose, if we have set ourselves up to a higher standard, even in the Act, by the way of our strategic directions and our other commentary, aren't we beholden to have a higher level than even the statutory ones that we can be relied on in our engagement and in our strategic directions? We've said that we're going to be open and transparent. If they're just rewording the Local Government Act, surely.
So that's, Michelle, I might tell you because I don't think that's a legal question. That's really a question for the council table. We've relied on legal advice as far as the process that we're currently in, but respect the fact that's a decision for the council to make in terms of the strategic directions and whether or not you feel that the reasons why we have set out as staff our recommendation are consistent with where you would like that to head. But I think that's more of a question for myself in terms of the staff advice and for yourselves in terms of the decision.
Well, I actually thought there was a legal test that was higher, but that's okay. It's yeah.
Thanks. Any other questions, Councillor Scott?
Sorry, it wasn't a question. I was going to.
Okay.
Can I ask a question of them then?
Councillor Malcolm first. Thank you, Councillor Laws.
Thank you.
Look, just wanted to test a couple of wee pointers. In the letter or in our council paper, it is said that we are giving a draft of portions of our section 32 to the minister. I assume that will be labelled as draft. And if we in fact decided to go public, whatever that would come in front of the public would be clearly labelled as a draft. Am I correct in that assumption?
If we took it in public, then it's marked as draft.
Thank you. So, and for accessibility to all, once it is noted, if we go out, if we take aside this particular letter or conversation that we're holding at the moment, if we say any information that council decides to go public on, that is available at the conclusion of a meeting to everyone, or everyone who wishes to partake in that information, and as quickly as they wish to partake in that information. So we decide to put something. We discuss. We say we're going to put this. We're going to put a policy or a motion straight onto our website, made available to the public, so anyone can access that.
Yes, if a decision of a council to put something up, anyone can access it.
Yeah, so therefore it's how accessible that is becomes your choice as a ratepayer or.
I see what you mean. Yes, correct.
Yeah, sorry.
We don't directly communicate with everybody. We make it available. Sorry. Yeah.
Thank you. Yeah. That's all.
Sorry, I'll come to you, Councillor Laws. We'll just clear a few other questions. Councillor Mifam. Maybe you're there, Councillor Mifam. You might be. I don't think you muted. Yeah. Oh, sure. Sorry, Councillor. No.
Just back to Michelle, question for Michelle. I just was a little confused when you mentioned that our response to the minister was in confidence to indicate there was some suggestion that it wasn't in the public arena, because all the letters, the 2 letters we've received, are in the public arena. So could you clarify what you meant in that regard?
My understanding is, at least for the extracts of the draft Section 32 report, that would be provided in confidence to the minister on the base at this stage, on the basis that it remains draft until such time as the Section 32 report is finalised and made publicly available.
Yep, council noted.
Can I just follow that up with the question? The document essentially that we've got in front of us today is in essentially 2 parts. There's the commentary, the first 4 or 5 or 7 pages, before it flips into extracts from the draft Section 32. So the commentary gives an overview of the process since we started talking to our community and the various changes that have been proposed at this point. So I suppose my question is, in terms of legal confidence or obligation of confidence, is there a difference between the first 7 pages as compared with the extracts directly from the draft Section 32?
Excuse me, sorry. Yes, I have considered that matter in the context of whether there is a difference between the narrative response to the draft Section 32 extracts that are attached. There are aspects of the response that do summarise and go into some detail of what is in those extracts of the Section 32 report. So in my view, those parts of the response should also be provided in confidence, as is the change in direction in terms of the policy response since engagement and consultation, on the basis that those decisions haven't been yet made by the council. Excuse me, they do remain staff recommendations. And it is in the context of the draft plan at this stage. So in my view, those parts of the response, there is a reason for those to also be provided in confidence as well.
Thank you.
Hey, we'll try councillor Mifam again.
Yes, look, sorry for that. Can you hear me now?
We can, thanks.
Look, and you might have covered it, but I'm just really interested in when the letter to the minister is actually also a public document. Is it as soon as we send it to her, or you may have answered that? Sorry if I missed that.
So that would be subject to the decisions made today, councillor. So at the moment, we are suggesting that the material within that letter, or some of that material, would not be made public. But for the reasons that Michelle's just outlined. But that's still there is the opportunity for myself or the council table to resolve to release some or more of the letter.
So we're about to have a discussion about whether that happens or not, and at the moment we're debating whether we have that discussion in public or in private. So okay, that's clear. Thank you.
A question from me for the Chief Executive, which I think we're probably aware of, but we have a choice today to decide to go into public excluded or not, but the Chief Executive has a choice on what material is released publicly as well. So yeah, so could you just outline the difference in responsibility there perhaps? I might have summarised it.
Yeah, I think it was summarised quite well. So we're I don't think I'll add too much to that. Yeah.
Right, yep, councillor Weir, sorry, councillor Laws, you're welcome to go
I've got
as
a
well.
question.
Yep.
One of the, sorry, this to Michelle. One of the very first case laws on excluding the public from council meetings was by Sir Brian Elwood in 1994. I've got it in front of me. It was a decision of a local authority's Environment and Planning Committee to exclude the public from a meeting at which a draft regional policy was considered and the inappropriate use of Section 48 to do so. This is 30 years ago, one of the very first case laws on this issue. And one of the points that Brian Elwood made in that particular pronouncement, which has become part of the lexicon now, obviously, of the Chief Ombudsman of the Office of the Ombudsman, is that deliberating upon a regional policy statement was not a good reason to proceed to exclude the public. And the reason why was because you haven't made a decision yet. You're discussing it. You haven't made a decision. You're just discussing it. You haven't deliberating. You're discussing it, A. And B, the other point that he made was that, and everybody affected by that decision has appeal rights from it. Okay, so even if, now in this particular case, we're not making any deliberations today at all, apart from to answer a letter. And if Elwood's statement of 30 years ago was it was wrong to exclude the public, and that was to do with a regional policy statement, for God's sake, this is a little bit lesser in the hierarchy in some ways. This is a letter to the minister to answer specific questions about decisions we haven't made. Then surely that case law, the Ombudsman says that it doesn't apply. That's the first question I have to you. The second is this. You've stated today, orally anyhow, that if this matter was to go out, the breach of confidence that you're talking about would be that some people might be advantaged because that Section 32 report would be out there. Sorry, if you're going to use that logic, everybody would be advantaged. I mean, it's public document once it is discussed in public and becomes public. So no one's advantaged or disadvantaged, are they? Because every member of the public, whether they are a submitter or not in the future, gets equal access and equal availability to the same document. I'm just asking that. Isn't that the case? Is the case, Michelle?
So if I address your second question first, so in the context of this material, it is draft extracts from the Section 32 report. If that is made publicly available as a result following this meeting, yes, the public at large does have access to that information should they wish to seek that out. That is different to once the Section 32 report is finalised and is actually made publicly available through public notice. So there is an expectation from the public that they would receive the Section 32 report when it is publicly notified. I would also say part of my consideration is these are extracts from the Section 32 report only. There are other aspects of the Section 32 report that are relevant to the topics that are addressed in the response, that if the public is looking at this document, the Section 32 report, it should be read as a whole, in my view, when it is made available to the public, rather than extracts that there is a risk that may be read out of context, particularly out of context from the consideration of the objectives of the plan and the integrated management chapters as well of the plan. So there are very topic specific extracts that we are discussing as part of the response.
The first point though, about the precedent set by Sir Brian Elwood.
Yes, so in that situation, there is a ground under Lagoima where if you are making deliberations that are subject to a right of appeal, there is a specific ground that you can, that the council, that may be a ground for withholding or excluding the public. That ground does not apply in this instance, as the council is not making a decision or recommendation today that is subject to a right of appeal. That will come at the time that the council considers the draft plan for notification. So in this instance, my advice is in relation to the provision of draft material and that being subject to an obligation of confidence. And I think the consideration for the council today is whether it is in the public interest for that draft material that's still subject to review and change, whether it's in the public interest for that to be publicly available at this time.
Okay, thank you. Looks like we might be at the end of, okay, yes, sorry, Councillor Ware, you had your hand up
You go
first,
first. No,
actually,
I
sorry.
your other hands.
Yeah, thanks.
Just for the chief executive, just wondered if you could outline what the consequences of theoretically doing this all in public would be for the land water plan process. And
I can't speak to the entire process, but in terms of if a decision is made to take the paper in public, I'd just ask for an adjournment just to take advice on whether I would want to review any of the material that forms part of that of that paper. That would be the process. So I'd need to go away and have that conversation.
That's probably a good thing to do.
Councillor Wilson.
I understand that some councils use their section 32 and clause 3 analysis or consultation, and so if that happens, which I have had confirmation several regional councils have done that, I'm really bemused why we can't do it here at this late stage. But so is it the significance of the draft part that you're concerned about?
That it is draft, that it is extracts only. It is still subject to review and change. So the section 32 report is still in its development. And there are matters within that report that may change prior to notification.
Okay. Oh, sorry, I didn't mean to interrupt. I thought you were sorry. The other question I've got, and this really is confusing me now, because we went out to the community and we discussed some of these ideas with them, and we asked for their feedback. Now, we either did that, and I was at some of those meetings, and on some topics we did it really well. So I have some confidence in us being able to relay that. Other topics we didn't necessarily cover off, but we either know the views of the community and their thoughts on these things as required under section 82 of the Local Government Act when we do our clause 3 consultation, or we don't. And so I'm really, we decided not to do a full consultation at the clause 3 because we presumably knew what people otherwise thought. That's the only reason why I can surmise that we didn't go wider. Or give them more details.
Just checking, this is a question on why we are moving into public excited or not.
It is about the section 32 and about its, the fact that we had that data and we've done that consultation and that's fed in, I presume, to the section 32, and that gives us the basis of the options that are relayed in the paper. I can't understand why that hasn't already been made public, really, in those consultations. Because that's the justification of putting the options out to the community in the first place.
It's probably not a question from Michelle either.
It's a broader process question.
Yeah.
Well,
He's commenting on the fact that it isn't.
Well, Michelle, then,
at the moment.
If this data was in the public domain for the purposes of consultation early on, is it still, and it's really Michael's point again, and just done a different way, if that data and those considerations were part of the consultation that were done when we did the community meetings right at the start, is it fair to say that they should still be done in confidence now? Because they have been out there with the community.
I think there are elements of it that may have been discussed with the community during engagement and then under clause 3 consultation. With the section 32 report, the section 32 report does actually summarise and respond to further feedback and information received through that clause 3 consultation, and then again through clause 4A consultation. So there is a reason for the section 32 report in its entirety not to be available at that time of engagement and then clause 3 consultation.
I think you've outlined those reasons earlier on as well. You have covered that. Councillor Kelleher. Yeah, we need to be moving on or we are going to run out of time. We've actually got a mayoral forum later here today as well. Thank you. Sorry, Councillor Kelleher. Yep, you can do your question.
Yep, thank you. My question is, why is the section 32 report in draft, or any part of it even being attached to this letter? The minister hasn't asked for it. The letter doesn't say, can we please have a look at your draft section 32 report? It feels to me as though it's being used as a convenient example or reason to be able to have public excluded for this discussion.
So Gary, I'll take that one. So the questions asked by the minister, the information that best responds to that is contained within the section 32 report. And you note, that is why it's referenced. Obviously, we have the narrative piece, which answers some of the questions, but some of the questions were more specific, and the best way for it, or in staff view, staff recommendation is that the best way for us to respond to those is by demonstrating that how that information has been used within the section 32 report. So that's the reason that it's in there. Some of them we could answer without, and some of them we felt it was best to respond by using extracts. But again, if the feeling is that there's an alternative to that, then that's part of the debate if we get to the debate on the content.
Madam Chair, can I ask a question of Richard?
We're actually, like I said, running really out of time.
This will be really,
We're
really
going
quick.
to miss the ability to actually
Really quick.
present the paper. So,
Yeah, no. Then why don't you take, I can understand, okay, so there's a simple compromise here. Why don't you then answer the question that the minister's answered? She's answered you six questions. You just take the information that you researched in providing the section 32 report. So that information that's currently in section 32, it's information. That's all it is, Richard. It doesn't have Holy Writ status. And then take that particular information to answer the minister's questions. You don't need
So
to
you
keep the
could
section.
direct us to rewrite it that way
we've
today.
got a choice
Yeah,
to
okay.
make,
That's
and
a
we need
choice.
to make it
Yeah,
now
yeah,
in terms
okay.
of whether we go into public
Right.
excluded or not.
Just, on that point, if we, sorry, I think this is important because as the CE then, if we go into open to decide to stay open, will you then look at the paper that you are provided and possibly reframe that?
Yes.
Thank you. Comfortable. I'm just making
Would
sure
that
that
be
we've got
done
that
if you were
opportunity.
public excluded too, so that you could cover all the things that are, we've just heard, confidential, and then decide which material is released or not as well as an option.
Yeah, there are.
So there's
there are
two ways.
different options.
Yeah.
There's that option or the debate on the substantive content could happen in non-public. The question and answer, and then the debate could then go back into public, provided that the council was aware that the material contained within that report. You just need to be very conscious of what was being discussed during that public debate. But there are different ways of managing it.
Yeah, it's a shame we
It's
didn't have
challenging.
this chat beforehand, because I can see now that
Yeah.
if you redrafted the paper, you'd make
Yeah.
everybody happy, Richard.
I don't think
Yeah, it's the chief executive responsibility, what material is presented and also what material is presented in public or public excluded too. So, yep, we've got what we've got. And I don't want to take any more questions at this point, really. We need to, make a decision on this unless it's absolutely crucial to the process.
It's not a question.
Yeah, okay. Is yours a question, councillor Scott? Rightio, so we've moved and seconded. Councillor Laws has already said something. Yep, councillor Noon.
So mine's a procedural one. So
Oh, right,
I
okay.
just want to flag a foreshadowed motion that we discuss the report, including the narrative from pages 5 to 11 in public, and not the pages following in relation to section 32. I'm just letting you know, so if the motion that's on the table fails, that would be my plan.
Councillor Scott.
Thank you. I want to speak to the motion.
Microphone.
Well, firstly, I disagree with the previous comments because it's not all, in my view, it's not all about section 32. The front end report actually talks about council's stance, draft stance on particular policy. And my understanding is that it's appropriate and essential to keep that confidential at this point. Proper process. We have to write to the minister, I think, by the end of today, or is it today, CE Richard?
That's the 20 day time frame.
Yeah, we have to write to the minister today. The minister has written specifically to the OSC on an important matter. In my view, it is appropriate and respectful that the OSC respond in confidence to the minister. Ideally, it is then up to the minister if they see fit to release any information. It's actually time to get on this process, proper process.
Okay, councillor Malcolm.
I wanted a question on that because I just need to know if we supply something to a minister in confidence, surely a minister, surely a minister wouldn't be allowed to release that information unless we gave permission. I'm sorry, but that's, I understand what you're saying.
I can't give you a specific response to that. I don't know whether Michelle will be able to. My expectation is that we remain in regular communication with the minister's office, and I would expect those, the conversations in the same way we have when we've received letters from the minister, have always checked with the office before including them or sharing them more broadly.
Any further?
Just very
debate?
quickly.
You've actually already spoken in debate. Thanks. Councillor Summerall.
Yeah, look, I agree that our default position is openness. However, having received that legal advice and heard the discussion, there's also previous discussions we've had about the problems of making drafts public when we're not seeking further consultation on it. And I also note Michelle's advice that the narrative contains summaries in some detail of what was in the section 32 draft there, so that wouldn't be appropriate to have publicly profiled. So I will be supporting moving this into private, non-public session.
Councillor Forbes.
I have some sympathy with Michael's position, and I'm not sure that our legal advice stands up with my understanding of the law, that there really is a position to do this. And I will likely support us doing this in public, although I do have some concerns about it too. So I'm still interested in hearing people's opinions if there are any left.
Councillor Noon.
Speaking to the motion, I can't support dealing this item in the public arena. I've offered a suggested way forward, sort of $1 each way. And why I've done that is I've read that narrative 3 times and I don't feel as if there's any information in there that would prejudice the following processes further down the track with the draft land and water plan. I can recall back to the previous correspondence with the minister, we quoted fencing costs for setbacks. And I can't recall any suggestion that that needed to be done in confidence. So I just feel the narrative would help our wider community to be, I suppose, better informed at this point in time, because that has been an issue for us to be able to, I suppose, keep our stakeholders up to speed with where we're at with this process. So I think it's valuable information that doesn't need to be withheld in non-public and should be shared. So I'm really speaking to the foreshadowed motion because I'm not confident I'll get another opportunity.
Wilson.
Well, I am happy to second the foreshadowed motion. I do support that. I think we're here to be open and transparent. I think this has got people's interests. They'll be watching this. I hope they are. And I seriously think that if there are any questions, which I'm concerned that there aren't any, but let's deal with the paper in public and leave the Section 32 stuff out is would be the best way of dealing with this and being as transparent and open as we could be.
Councillor Meetham and then Nicole. Oh, sorry, I was trying to get to the paper as well. Councillor Meetham.
Yes, look, I have some sympathy for Michael's argument. It was compelling, but it is also very useful to have had Michelle from Wynne Williams also giving us her advice. Much as I respect Michael, you're not practicing at the moment. And so I will be going with the advice of Michelle, and I will support going into a non-public meeting. Thank you.
Doesn't need to practice, it is already good.
You are okay, Councillor Cole. Yeah, I support going into public exclude. I move to the motion as well, so right of reply. And the reason for that is we've just heard that we could move into public and exclude discussion on some really significant parts of what we actually need to discuss, I feel. So, yeah, I mean, there is the option, as I've said before, of going into public excluded, being able to discuss absolutely everything that we've got as a council, and then be able to decide from there, does any of this need to be in public? If it does, we have a duty to make it public, so that isn't an option. So yeah, that's the way that I prefer to go, and I'm happy to state my position quickly on that right now. Thanks, Michelle, for your feedback as well around process and yeah, why you wouldn't be releasing ahead of a Section 32 and notification as well in your view. Okay, we might call it division. Yeah, thank you.
Completely up to you, Chief.
Might be easier. Thanks, Holly.
Councillor Forbes.
Is it clear what the motion is?
Oh, sorry, we can't hear you, Councillor.
You're on mute,
Forbes.
Alex.
That's what I'm sorry, it is clear. If you've got your agenda in front of you, it is the
Alexa's on.
Sorry, I was just looking for the agenda while I was trying to find that. I'm on reflection, I'm going to support the motion. Go into public excluded.
Councillor Kelleher.
No.
Councillor Laws.
No.
Councillor Malcolm.
No.
Councillor McCall.
Yes.
Councillor Meetham.
Yes.
Councillor Noon.
No.
Councillor Scott.
Yes.
Councillor Somerville.
Yes.
Councillor Weir.
Yes.
Councillor Wilson.
No.
Councillor Robertson.
yes.
Secret 7.
7, 4, and 5.
Secret 7.
Yes.
7-5 motion is carried.